Today's lecture focuses on the United Nations human rights system, and in particular, the treaty bodies that monitor the implementation by states parties of individual covenants and conventions that are part of the United Nations system. Here's a brief overview of what we'll discuss today. We'll first provide an overview of the UN human rights system as a whole and the place of UN treaty bodies within it. We'll then review the functions that treaty bodies perform, and we'll focus in particular on the state reporting to the treaty bodies. We'll review the procedures or processes of state reporting, the cycle of state reporting, and then we'll have a discussion of a specific case study of the right to liberty and security in Sudan. Finally, we'll evaluate the state reporting process in light of the case study. Now, the UN treaty bodies are institutions that we have encountered in previous lectures of this course. They are independent experts who are appointed from a cross-section of regions to monitor the implementation of each treaty by its states parties. And the basic rule here is there is one treaty body per treaty. So some of the treaty bodies that we've looked at in the past include the United Nations Human Rights Committee, the CEDAW Committee, and the Committee on Economic, Social, and Cultural Rights. Each of those committees monitors its respective international agreement. Let me give you a schematic overview that will provide a way for you to understand the place of the treaty bodies within the United Nations human rights system. You see in the rightmost column the list of some, not all, of the treaty bodies, and the ones we've studied before I'm now checking off. And these bodies all perform quite similar functions. So although we'll be talking about examples from the CEDAW Committee and the UN Human Rights Committee, we could have picked examples from other treaty bodies. I just want to preview that in the next few lectures of the course, we will be talking about the charter bodies that are also part of the UN system. But for now, we're just in the most right-hand column. So let's actually review some of the monitoring mechanisms that treaty bodies employ. We've seen a number of these before. They promulgate or adopt general comments that interpret the rights protected by the treaty for all states parties and provide additional guidance to those states. They review complaints from individuals and sometimes from NGOs alleging violations protected in the treaty. They can investigate gross or systemic violations, at least some of the treaty bodies can. And finally, they review and comment on periodic reports from states parties. And we'll look at a number of these different monitoring mechanisms in some detail, focusing in on the second one, complaints, and on the reporting process, the last monitoring mechanism. Before we do that, however, I want to raise an overarching question about the influence of the treaty bodies. So it's true to say that none of the treaty bodies have the authority to enforce human rights conventions that they monitor, nor can they issue legally binding rulings in the way that courts can. So this raises a question: how do these treaty bodies actually influence the behavior of states parties with regard to promoting and protecting human rights? And the response to that question, I would submit to you, is that treaty bodies exercise soft power. That is, they influence the behavior of states in a variety of different ways that don't require legally binding rulings or enforcement mechanisms. So first, they provide information. They identify in detail whether a treaty party is respecting or violating a particular international norm. They publicize human rights abuses. That's a form of naming and shaming that we mentioned in the lecture on international relations theory. They develop guidelines on specific human rights topics and issue recommendations to states both individually and collectively that might persuade them to change their behavior. And they also interact with NGOs and individuals who, in turn, can lobby or litigate against states in domestic legal systems. And this is, I would say, a form of empowerment. So you can see here that some of the ideas behind at least two of the schools of international relations theory, liberalism and constructivism, appear to support the influence that treaty bodies may have with regard to the behavior of governments. Let's now turn in some detail to the individual complaints or individual petition procedure. And there's one very important institutional feature that you need to know about. Most of the treaty bodies can receive petitions from individuals, and as I said earlier, in some cases NGOs, who claim that the human rights protected in the treaty have been violated by a state. But that is only the case if certain jurisdictional and procedural requirements have been satisfied. First, and most importantly, the state concerned has to have accepted the treaty body's competence to receive such complaints, and as we'll see in a moment, not all states have. Secondly, the individual must exhaust domestic remedies. And that's another way of saying that if there are ways to obtain relief, compensation, a change in policy, etc., that should be pursued at the domestic level, with international mechanisms like the treaty body serving as a backstop if governments don't respond to attempts to obtain domestic remedies. And finally, there are other procedural requirements that would also need to be met. We'll explore some of these issues in the coming weeks. For now, I want to give you a concrete example of how the individual complaints mechanism works by reference to the optional protocol to CEDAW. This optional agreement, so obviously it's not required by virtue of its title, authorizes the CEDAW Committee, the treaty body for the Women's Rights Convention, to review complaints from individuals and NGOs alleging violations of CEDAW, and also to investigate grave or systemic human rights violations of that convention, but only with regard to those states that have ratified the optional protocol. The optional protocol was much later than CEDAW, which you may recall was adopted in 1979. The optional protocol was not adopted for an additional 20 years. It entered into force, however, quite quickly by 2000, and as of January 1st of 2014, 104 nations of the 187 states parties to CEDAW had ratified the optional protocol. That's a little more than half. For those states, there is an additional monitoring mechanism that the committee has at its disposal to review compliance with the treaty. For those states that have chosen not to recognize this mechanism, the other mechanisms we mentioned will be available, most particularly the state reporting process. Now, the different treaties have a number of different rules here, and I'm going to generalize, but the basic idea is that each state party to a treaty submits a report to the treaty body within 1 to 2 years after ratifying that treaty, and every several years thereafter, usually between 2 and 5 years. And these reports describe how the state has implemented the provisions of the treaty and the challenges that it has experienced in its efforts to fully comply with the rights and freedoms that it contains. The reporting process, as I'll now describe, is an opportunity for a dialogue between the members of the treaty body and the government officials who are in charge of preparing the report and also implementing human rights commitments within its domestic legal system. And in order to facilitate that dialogue, the committees have a longstanding practice of inviting and reviewing so-called shadow reports by NGOs and civil society groups that highlight particular problem areas or omissions in the state's official report. So this is, I think, quite an interesting opportunity because the state is aware that it will also have to contend with reports that NGOs have submitted, and that hopefully will keep it honest in describing both its implementation successes and the challenges that it has faced. Let's now focus on some of the procedures of the state reporting process. The first step is that the state prepares and submits its report to the relevant treaty body. The treaty body then prepares a list of issues and questions that it submits to the state. The state may reply to those issues and questions, and then there is a review of the report that occurs in a public session in which the state representatives are asked questions by the members of the committee. The committee, after considering the public session and the questions and answers, issues concluding observations and recommendations to the reporting state and indicates that it would like some follow-up or further information on those concluding observations and recommendations, including in particular in subsequent reports by that state. Here's a schematic that illustrates the cycle of reporting. And you can see that it begins at step 1 when the state party submits its report and continues with subsequent questions and responses leading to this constructive dialogue between the committee members and the state's party's delegation. Notice here you'll see opportunity for input from the UN system as a whole, from NHRIs or National Human Rights Institutions, and NGOs. So you can see how the cycle of reporting proceeds over time, and the hope is that the state's compliance with its treaty obligations and its implementation of the treaty into its domestic legal system will improve over time. To give you a very concrete example of how the reporting process works, I'd like you to pause the lecture for a moment and consider a case study of the 2007 and 2012 reports of the Sudan to the UN Human Rights Committee regarding the right to liberty and security of the person, which is protected in Article 9 of the ICCPR. When you've finished reading through the materials available on the Coursera webpage, please continue the lecture.